the incorporation of the company. The Companies Act, Section 7, 8, 9, 10. Basically, these sections have elaborately, not 8, 8 deals with the NPO and its incorporation as well, right? So Section 10 basically deals in detail the process of incorporation. Read with Companies Incorporation Rules. We will be talking about Incorporation Rules 12. Rule 12 of Company Incorporation Rules. We will be reading section and rules together. So it defines that you need to make an application for registration with the registrar of company with whose jurisdiction the registered office is proposed to be situated. Normally, ROC is attached with every state. Every state has its ROC. So if you are making a company, incorporating a company in, say for example, New Delhi, so you need to apply to the ROC New Delhi. Basically, you need to understand that we are applying to the ROC of a state, but it is not visible clearly when you are making an application online. Normally, now the online application is made in form SPICE Plus. That is, what is the full form of SPICE? Simplified Proforma for Incorporating Companies Electronically Plus. Earlier it was SPICE with some modification. Now the new form is SPICE Plus. Actually, the the form is INC 32. The fancy name of this form is SPICE Plus. Along with the SPICE Plus, you need to attach. This is of course an online application form. This is a digital form which you need to apply to the on the website of MCA. With this particular application, you need to attach certain documents, that is the memorandum of association, the articles of association, which we will be discussing tomorrow, duly signed with all the subscribers, that is the 2 subscribers, the 7 subscribers which had initially agreed to form a company. Along with it, you need to file a declaration, that is a statutory declaration in form INC 8. That is, the INC 8 will be uploaded as an attachment to the main form, that is SPICE Plus. So what is the first attachment of SPICE Plus? MOA AOA. What is the second attachment of this form? INC 8. This is a legal declaration by a practicing professional. It can be a practicing advocate, it can be a practicing CA or CS or CMA, who will declare that he or she has gone through the entire legal procedure and all the legal documents which are presented in the course of promotion and incorporation, and all the legal formalities have been complied with. This undertaking, this declaration will be given by the practicing professional. So, and any person named in article as director, manager, secretary, all these persons have followed all the legal formalities relating to the incorporation of company under the Companies Act. This declaration shall be filed along with the SPICE Plus form. So SPICE Plus will be what will be the attachments of SPICE Plus? The memorandum and articles. Of course, these will be e-memorandums and e-articles. Apart from a memorandum article, a declaration by a practicing advocate or a practicing professional in form INC 8. This is nothing but a format of what to declare. That they have the promoters and the initial directors and all the initial legal formalities relating to the incorporation have been complied with. Another declaration from each of the subscribers. Who are the subscribers? Those 2 persons, those 7 persons. And from the persons named as first directors. You need to declare at the time of incorporation who will be your first directors soon after incorporation. That these persons, the subscribers, that is the initial members, and the first directors, initial directors, they are not convicted of any offense relating to the formation of the company earlier or the management of any previous company already in existence. Say, for example, there is a company X Limited, which is already making defaults. You are the promoter or shareholder or director of the company, and now you are again coming up with the incorporation of another company. You will not be allowed to do so, because you need to declare here that your earlier companies or in the companies in which you are directors or promoters or shareholders are not found to be guilty of any fraud any breach of trust to any company under this act or previous act during the last 5 years. In the last 5 years, if you are already existing company where you are a promoter, you are a director, you are a shareholder, in the last 5 years, if you have breached any of such conduct, you will not be allowed to float another company, or you will not be allowed to become the subscribers to the memorandum or directors of another new company. And all these documents shall file with the ROC. Apart from it, you need to declare the address of correspondence, that is your registered office. Normally, earlier it was there that you have to mention the entire complete address, but it is not so now. Now you are only required to give the name of the state. You need not to give the complete city or the complete address of your particular registered office. Once the company is incorporated, in the next 15 days, you can give your full details of your address to the ROC at the later stage. That we'll be discussing at the later slide. Apart from it, you need to give the names, surnames, family names of each of the subscribers to the memorandum, including their proof of identity, in which the PAN card and the Aadhaar card is mandatory. You need to give the details of all those initial memorandum subscribers. You need to mention the director's details, the person named as directors, unki sari details as their names, their surnames, their DIN number, which is mandatory to be taken to become a director, their address, their nationality. We'll be discussing how the DIN will be taken at the later stage, don't worry. The nature of interests of the persons who are named as first directors in other firms or body corporates. Say, for example, if your company's proposed director is already a partner in any other partnership firm or any LLP, or is already a director in some another company, you need to disclose that those persons whom you are making the first directors, how they are interested with other companies or body corporates. What is their nature of interest with other firms, other body corporates? You need to mention those particulars. So these are certain documents which you need to attach. These all documents will be sent as the attachment to the main form, that is SPICE Plus. So far, so okay? In subsection 2, 3, and 4, read with Rule 18. These documents will be filed with the ROC under section 7, subsection 1. And after carefully analyzing all the documents, the ROC, that is the MCA, will digitally issue you the certificate of incorporation. The format of certificate of incorporation is given under INC 11. This is not a form which you need to file. This is a format in which the ROC will issue you the incorporation certificate. From the date mentioned in the certificate of incorporation, the ROC shall allot you the SIN number. Rather, we can say the SIN will be allotted to you, that is corporate identification number. That is a 21-digit number. It is a unique number for every company, right? And this needs to be included in the certificate of incorporation. So once the SIN has been allotted in the certificate of incorporation, it is deemed that your company has been legally formed or incorporated. All these documents relating to the promotion and incorporation and all other legal documents of the company shall be preserved at its registered office till the dissolution under the act. The documentation, that is the preservation of documentation, has been clearly mentioned in the Companies Act, that these basic documents and some other documents need to be permanently reserved or permanently preserved in the company. And some documents can be disposed after every 7 years. That we will be discussing at the later stages. But that is for sure that the basic incorporation documents, the memorandums, the articles, they need to be preserved for life till the dissolution of the company. Now, if the promoter, director, the practicing professional like the practicing lawyer, chartered accountant, if anybody has given any other false or incorrect information, then for false documentation, there is a punishment. If any of the person, they have given any if you have suppressed any material information which was right, which you hide, or you gave any untrue statement, you need to face the penalty under section 447, that is the penalty for fraud. So if you are caught during incorporation itself, we will be penalizing you in terms of 447. Subsection 6 is little bit different, that we incorporated you, but at later stage we found that the company which you incorporated was based on the fraudulent manner. Then all the promoters, all the first directors, and the persons making declaration, these are the practicing professionals, that is practicing advocates, CSCS, CMA. They will be held liable under 447. So what is the difference between section 5 and subsection 6 is, this is during the process of incorporation, you are caught by the ministry. And in the subsection 6, it is specifically highlighted that if ROC had given you the certificate of incorporation, and in any point of time thereafter during your lifetime, any time if you are caught that you filed false declaration, you hide some material facts, then also you are liable to face the same penalty under subsection 4 under section 447. So this is the only difference. This is at the time of incorporation. It is at, and subsection 6 deals with at any point after incorporation. So this is the basic difference between the two sections. Now, under subsection 7, if without prejudice, without having any regard to whatsoever is written under subsection 6, if you are making a company on incorrect statement, you are misleading, you are representing misleading facts, then the court, the NCLT, may, on the application made to it, who is going to make an application to an NCLT? Any aggrieved party, any regulatory body, anybody, your debtor, your creditor, your shareholder, your debenture holder, any regulatory body, income tax officers, ROC itself, uh, any authority, any shareholder, any debenture holder, if they caught you, they can directly apply to the NCLT, and NCLT can pass an order that in the public interest that the management of the company is false, or the management of the company is misleading or fraudulent. They can pass an order for the regulation of management. They can pass the order that the members, all the members' liability shall be unlimited because you are making fraudulent affairs under the company. Or they can straight away direct the ROC to strike off your name, to remove your name from the register of companies maintained with whom? Maintained with ROC. Of course, they can alternately pass an order of winding up of the company. There is a difference between the order of winding up and order of removal of name. See, if your company has not having any sufficient any assets or liabilities, then the ROC can straight away direct the striking of your name of the company. But if you are having various assets, various liability, then the formal procedure of winding up shall be undertaken. What is the formal procedure of winding up? The assets will be liquidated through a liquidator. Who is a liquidator? The advocate, the court person. The liquidator is attached with the court. That is, the court allots the liquidator. That is the official liquidator of the court, appointed by the court, shall act as a liquidator of the company of that particular state. And then he will take the custody of all the assets and liability. He will dispose the assets. He will pay the liabilities. That is a formal procedure of winding up. Or any other orders as may deem fit. It includes imposing fines to the fraudulent directors, to the shareholders. It involves the imprisonment order or any such order. Compensation order, the NCLT can give any such order against the directors or promoters or the shareholders of the fraudulent company. But before giving any such order, the NCLT shall give the company a reasonable opportunity of being heard. Ex parte decisions. If we talk about the legal interpretations, what we are trying to say, ex parte decisions will not be given by the court without hearing the company's official, right? So this is all about section 7, subsection 7. So far, so good. Of registration, section 9 deals with once the certificate of incorporation has been allotted, there has written the SIN number, point number 1. This is the unique identity of the company. Second is the date of incorporation is mentioned in the certificate itself. From that date is allotted with by the ROC. That date of incorporation is very important in pursuance of the law. From the date of incorporation itself, the subscribers shall be deemed to be the members of the company. The first members of the company will be the members who are the subscribers to the memorandum, or any other member who is named as member in the memorandum, right? The company will become the company. That is the separate legal entity. From that date itself, the company shall be taken as a body corporate under law. The company will be given all the features and all the powers of the company, having limited liability, perpetual succession, making agreements with the outsiders, all these contracts, to make and to enter into a contract, to sue, to be sued by other person in the name of the company. So that is the effect of the registration of the company. That is, a company is being birthed, is deemed to be born in the eyes of law. Simple. This is the effect of registration. Now, another section is section 10A, commencement of business. Earlier, it was not there in the Companies Act in 2014, but now it is there under 10A. Commencement of business. Now, if you have incorporated a company, you are having a share capital, you cannot commence your business. You cannot exercise any borrowing power. That is, you can't take any loan or debenture unless you have mandated certain provisions, unless you have filed some declaration. What are the declaration? Within 180 days from the incorporation, a declaration need to be filed by a director. Any of the director can file the declaration. It is not to be signed by all the directors. You choose any one single director through a board resolution. He or she will file a declaration within 180 days in Form 20A. INC 20A. See, this is a series INC which deals with the incorporation forms. So INC 20A, that every subscribers had subscribed to the shares, initial subscribers, and they had paid the value of the shares. So the initial subscribers need to pay the value of the shares within 180 days so that this declaration can be made. And the company has filed a declaration, the verification documents of registered office. See, every company needs to update at the time of incorporation. They need to update, if not the entire address, then at least you need to update in which state you will be having a registered office. So at the time of incorporation, the ROC gave you the liberty that you are not supposed to disclose the entire address, but only the state, name of the state. But in 180 days itself, you need to file the exact address, the detailed address to the ROC in Form INC 22. See, if you had given the exact detailed address at the time of incorporation only, you need not to file any further declaration to ROC. But if you had not given the exact detailed address at the time of incorporation, you need to file an INC 22. So it is very subjective matter that every company needs to file INC 22. No. If you had not given the detailed address at the time of incorporation, then you need to file INC 22. One more use of INC 22 is, now at any point in your life, if you change your registered office, then you need to file your INC 22, the details of your updated new address. But here we are talking about the first time INC 22. You need not to file that first time INC 22 if you had already given the detailed address in the memorandum in the time of incorporation. Now, if you had made any default, any of the clause A or clause B default, you will be charged with a penalty of 50,000. That means the company will be paid liable to pay the penalty. Penalty means who is the authority to pay impose the penalty? ROC. Where the word fine is there, the court, the NCLT will come into picture. But here the word penalty itself means you pay online to ROC, MCA website. Right? Every company will pay 50,000 and every officer, every single director, manager, company secretary, CEO, CFO, whomsoever are present in the company, they shall be liable for penalty for 1,000 rupee per day, during which the default continues. But maximum penalty to those officers is extended to 1 lakh rupees. And where no declaration is filed with the ROC under clause A, this is what we are talking about. That is the declaration under INC 20A. And in that case, if the ROC has a reason to believe that you are not carrying on the business, this is just for a dummy company. You had just opened up a company for dummy purposes, illegal purposes. You are not filing the INC 20A within 180 days, then the company, then the ROC may give an order of striking off, that is the removal of name of the company. This is basically the crux of section 10A.